Did you know that California was not always LGBTQIA plus loving? No. In 1850, shortly after having joined the United States, California adopted a criminal code prohibiting automy, both heterosexual and homosexual, with 1 to 14 years imprisonment. Over the following years, numerous people were convicted of automy, and the state law was amended to include oral in 1915. A bill was introduced in 1975 to repeal the state's automy statute, and same sex sexual activity has been legal in the state since 1976. In 1909, California passed a law providing for the possible sterilization of moral or sexual perverts. They were targeting gays. By 1948, 19,042 people had been sterilized under the law. California loves sterilizing people. That's a separate conversation. Okay. In 1951, the law was amended to remove perversion as a ground for sterilization. In 1977, California passed a bill that defined marriage as a personal relation arising out of a civil contract between a man and a woman to which the consent of the parties capable of making that contract is necessary. In 1985, the city of Berkeley became the first governing entity in the state to recognize same-sex couples legally when it enacted its domestic partnership policy for city and school district employees. California became the first state in the U.S. to legalize domestic partnerships between same-sex couples in 1999. Through the Domestic Partnership Act in 1999, California recognized same-sex relationships in any legal capacity. As of the California Domestic Partner Rights and Responsibilities Act of 2003, same-sex civil unions or domestic partnerships performed in other states or countries are considered equivalent to California's domestic partnerships. Proposition 22, an initiative passed by voters in 2000, forbade the state from recognizing same-sex marriages. This initiative was struck down in May of 2008 by the California Supreme Court in remarriage cases, but a few months later, Proposition 8 reinstated California's ban on marriages for same-sex couples. In 2010, a federal district court in Perry versus Schwarzenegger determined that Proposition 8 was unconstitutional due to violations of the due process and equal protection clauses of the 14th Amendment to the United States Constitution. People keep forgetting about those little clauses in the 14th Amendment: due process and equal protection. What you do for one, you have to do for the other. Okay. Anyways, but the United States Court of Appeals for the Ninth Circuit ordered a stay of the judgment pending appeal. So, in February 2012, a 3-judge panel of the U.S. Court of Appeals for the Ninth Circuit upheld the district court's holding in Perry v. Schwarzenegger that Proposition 8 was unconstitutional, because it was. It then went to the Supreme Court, who decided that Proposition 8 was unconstitutional. They lifted the stay put in place by the Court of Appeals of the Ninth Circuit, allowing same-sex couples to marry in California. In 2014, legislation was passed removing reference to marriage as a union between a man and a woman from the state's family code and updated the law with gender neutral terms to apply to same sex marriages as well as heterosexual ones.